theft, NJ 2C20-1 et sec. Okay, theft is another one of these long involved statutes in which there are many different kinds of theft and prescribed conduct that constitute theft. And theft is one of the original sins. It's pretty obvious what it is if you boil it down. You're taking something that you didn't pay for, that doesn't belong to you, and you want to permanently deprive the owner of it. In fact, at common law, larceny was known as the taking and carrying away or asportation of the goods of another with intent to permanently deprive the owner thereof. Then modern legislatures got a hold of that and created a bunch of different variations. So what I want to do today is go down a partial laundry list of Chapter 20 of the statute, the 2C Criminal Code, and just go through the major types of theft that I see mostly in my practice and that you're most likely to be charged with and needed help with. The first one is theft by unlawful taking or disposition. There's a Section A, theft of movable property. There's a Section B, theft of immovable property. If you unlawfully take or exercise unlawful control over movable property of another with purpose to deprive him thereof. A great example might be you see a bicycle that you want, you take it, you ride away with it, and you never intend to give the owner the bicycle back. That's theft of movable property. Theft of immovable property might be something like an interest in a property or some kind of trust or something that, is not a chattel or an actual something you can pick up and carry away. And same rules apply to that. Now, all theft, no matter what kind, is the gradation is set by the amount of money involved in the theft. So if the item that you allegedly stole is less than $200, it is a disorderly persons offense. Okay, punishable by a fine of up to $1,000, possible jail up to 6 months, and a disorderly persons offense criminal record, which is a criminal act that doesn't rise to the level of a felony. If it's $200 or more, but under $500, it's a fourth-degree crime, punishable by a fine of up to $10,000, minimum 1 year, maximum 18 months jail time, and, of course, a criminal record. If it's between $500 at issue and $75,000, it is a third-degree offense, punishable by a fine of up to $15,000, minimum 3 years, maximum 5 years prison, and a criminal record. And if there's more than $75,000 involved, it becomes a second-degree offense, which is punishable by minimum of 5 years, maximum 10 years, prison up to 7, jail time, criminal record, and a fine. And I believe the fine it's in excess of $75,000. It's up there. It's definitely get your attention. Okay, so that's 2C20-3. A second kind of offense I see a lot is 2C20-4, theft by deception. This is where you purposely obtain property of another by deception. You deceive that person by reinforcing a false impression that you intend to pay him when you don't mean to, and you never meant to pay him. It's essentially a modern definition of what we would call fraud in the inducement or fraud in the fractum. There are a number of ways you can commit this, but the gist of it is you're deceiving someone into thinking that you're not stealing something from him when in fact you always intended to steal something from him. The same sentencing guidelines apply. The value or gradation of the value of the item stolen is what affects the gradation of the offense and the punishment. A third kind that I see a lot is something called theft of services. This is where people perform services for an individual thinking they're going to get paid, and of course they don't get paid. Now this is a very lengthy section of the statute, and you can't really do justice to it in this video, but suffice it to say, if you trick someone into performing a service for you, like a lawyer or a doctor or an accountant, and then you never pay them, and you never intended to pay them from the beginning, that is theft of services. And then a fourth one, which is addressed in a prior video, is shoplifting. And that is simply theft of goods from a merchant. In other words, you're stealing something that is you can pick up and carry away. And is for sale in a store from a merchant who is a person selling things for a living. And that is also a involved long statute, which I dealt with in another video. But that is essentially what the whole Chapter 20 of the 2C Code is about. And the question is, well, how do I see this come up in my practice? Well, I mostly see people either committing theft of services or theft by deception or shoplifting, and then being outright flabbergasted when they're prosecuted because they don't understand what they did as a criminal event. Mr. Gravett, what can you do for me if I'm charged with this and, I need your help? Well, I've had really good success with these kinds of cases. A lot depends on the state of the mind of the defendant when they were allegedly committing the offense. In some cases, there isn't really great evidence. In other cases, there isn't proof that the person always intended to steal. There are a number of defenses that can be employed to get downgrades to these charges to things that are less bad for you. Okay, I'd be happy to help you if you need help. My address and phone number and all that is below. My information that you can contact me at. Consultations are free, but if you need to have a lawyer and you want to retain me, of course I do have to charge for that. So here's my information again. Thank you, and have a nice day.